Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Daniel Epps, Associate Professor of Law at Washington University St. Louis School of Law. We will discuss his draft article, Checks and Balances in the Criminal Law. So welcome to the show, Dan.
Thanks for having me, Brian. And I'm sorry to inform your listeners that I have a little bit of a cold that is making my voice not quite as mellifluous as it might be otherwise.
Well, I appreciate you soldiering through the cold to do this interview.
Anything for you.
Oh, thank you so much. You know that you're like my podcasting hero, and that this podcast wouldn't exist if it weren't for you. It was sort of like the inspiration for me to start doing it myself. So,
well, I appreciate that. I find that hard to believe. I'm sure you would have found a way to create this podcast no matter what happened in the universe, but I really, really appreciate you saying that.
So I really enjoyed reading your article, and I found it like really provocative, but also pretty convincing, I got to say. But for listeners who aren't maybe as familiar with some of the background concepts that you're wrestling with in the article, I wonder if we could kind of situate them in the conversation.
Yeah, absolutely. But let me just say one other thing for people who are not academics. Basically, I've for whatever reason, I've never been able to write an article that hasn't been called provocative. And provocative, I think, is the kind of academic, nice way of saying like completely, batshit crazy. So just keep that in mind. But basically, the paper is about the idea of the separation of powers in criminal law. And it's an idea that I think a lot of people just intuitively think is really important. And if I were to say something like judge, jury, and executioner in one person, that seems really scary. Or talk about, totalitarian societies where they have sort of politically dominated criminal justice systems. That seems really scary. And we think, we've got to have separation of powers. We've got to have a prosecutor and who's prosecuting violations of laws passed by an independent legislature and interpreted by an independent judge. And then a jury has to figure out whether you have actually committed the crime and so forth. And that's supposed to be a really important protection for liberty. But I have this kind of bad quality, which is I like to sort of go after things that everyone else thinks are totally obviously true and sort of ask why. It's kind of like a 3-year-old's approach to legal scholarship is like everyone just says something and I'm just like, why?
I wouldn't know anything about this,
Yeah. And, I've always been a little puzzled by our attitude towards the separation of powers, and because it's something that we just always say it's really important. And I always just sort of said, well, what is it that's important? How is it important? How does it protect the things that we care about? And so it's something I've been puzzling over for a few years, and I finally last year kind of got my act together and wrote this piece, which I've continued to revise, and it's one I've been really kind of letting simmer for a long time. And what I was trying to figure out is why do we care about the separation of powers, in criminal law, the idea that we're going to separate power over criminal justice between different decision makers or maybe different government institutions. Why do we care about that, and what is important about it? And let's kind of break down all the arguments. And in the course of doing that, I came to think that there's actually two different ideas that we tend to think of as the same, but they're actually quite distinct and they point in different directions. And one is the idea of what we call separation of powers. And that's an idea that, traces its way back to the French philosopher Montesquieu, who sort of said it's really important that you have the different powers of government be in different hands. And he said, let's legislature, executive, judiciary. So basically, government exercises different kinds of functions, and that we don't want those to be kind of like mixed up in the same person. We got to keep those separate, right? So that's one idea. That's the kind of pure idea of separation of powers. Different powers, different people. But then there's this other idea that's very much tied up with the American understanding of constitutional law, which is something we call checks and balances. Right. And we often think of these are the same thing. People will say phrases like separation of powers and checks and balances. They'll kind of run them all together as one idea. But I think that they're actually pretty different. And checks and balances has a different intellectual tradition. It goes actually much further. You can trace it back to ancient Greece. and earlier. And this is the idea that we're going to take the power of government, we're going to divide it between different interests, and they're going to check each other. They're going to make sure that no one person or faction or group is able to use the power of government to kind of dominate everybody else. And the thing that is different about the separation of powers idea is that checks and balances isn't necessarily invested in dividing government power by function, right? You could say we're going to have 3 different legislatures, and they're all going to legislate, say, but we're going to put different people in each of the 3 different legislatures, and they're different strategies. And what my paper ultimately ends up concluding is that the checks and balances thread in American constitutional law is actually much more important and the one that we should be cherishing and seeking to maximize than the formal separation of powers thread. We should be caring less about ensuring that the power of criminal justice is parceled out among these functionally differentiated institutions, and more focused on ensuring that power over criminal justice is divided between decision makers that have some incentive to check each other.
Well, why do you think it is that there's this prevalent tendency to sort of think of separation of powers and checks and balances as being similar or even different expressions of the same thing? I mean, is it tied to the way that kind of constitutional government was implemented in the United States?
Yeah, I think it's basically it's because our system happens to merge those 2 strategies. And people just everywhere tend to sort of assume that the way things are done where they are is just the only way it could possibly be done. And the Madisonian approach was to draw on these 2 different traditions and to kind of combine them. There's this one tradition that envisioned different government power, divided up among different interests in society, and often divided among classes in society, divided between a king and the nobles and the common people, and they're going to check each other. And then this other tradition of dividing power among function. And he kind of scrambled the 2 of them. He said, we're going to have separation of powers on these functional lines, but then we're going to kind of actually break the rules of separation of powers, because we're going to give the functionally differentiated branches of government this checking ability. So we're going to, normally the president's job, he's part of the executive, is just to do executive stuff, right? We're actually going to make the president a little bit of a legislator by allowing him to veto legislation. And so forth. And there's other examples like this, these kind of deviations from the purest form of separation of powers that are what we call checks and balances. Now, we tend to just think this whole system is the whole thing. It's separation of powers and checks and balances. But I think it's really important and useful intellectually to kind of be a little bit more specific about what exactly they did and why they did it. Now, the Madisonian theory was that if we do this, government officials are going to really care about kind of maximizing their own power. Ambition is going to check ambition, and that's going to cause Congress to check the president and so forth. And I think, people in the last couple decades in American constitutional law have come around to the view that maybe that wasn't right. And there's this very famous article by Darrell Levinson and Rick Pildes called Separation of Parties, Not Powers, where they say, look, the separation of powers between the president and Congress doesn't actually do that much work when both of those institutions are held by the same political party, because Congress doesn't have an inherent incentive to maximize its own power. When Congress is in Republican hands, it has incentive to maximize whatever Republicans want to do. When Congress is held by Democrats, it has the incentive to maximize what Democrats want to do. And when the president is also a member of the same party, they're going to cooperate and not compete.
Well, so, I mean, I found that really compelling, right? Because, I mean, I do feel like there's this unfortunate tendency to sort of look back to Madison as being a trump card for how things are going to work, irrespective of like what 250 years of history tell us about how things actually work. And it does seem quite convincing, that this sort of the kind of basic version or kind of simplified version of separation of powers and what it's going to do doesn't seem to do what Madison thought it would. But a lot of contemporary criminal law scholars have looked to separation of powers as being important to both kind of maintaining the legitimacy of the system and also to pushing forward criminal justice reform. I wonder if you could like spend a minute kind of putting a good face on that approach so we kind of have a sense of why other people think that this is the appropriate approach.
Yeah, so I think a number of people have written about this, and they've written some really important pieces. And in the piece, I engage a lot with work by Professor Rachel Barkow of NYU, who's written, I think, the kind of the best article on this topic. And I think where they're coming from is that kind of work is coming from is a recognition that like this is the system we have, and that in practice, our system doesn't seem to honor its own promises. In practice, in the way criminal justice works in America, both in the federal level and in the states, we don't really have a lot of practical separation of powers because the rise of plea bargaining has largely meant that most power is, for practical purposes, exercised by prosecutors, and that because prosecutors can sort of threaten to bring charges, serious charges against you to get you to plea, and that sort of bypasses a trial, bypasses the jury, bypasses significant judicial involvement. And what we don't have is the kind of multi-institution checking that I think that the system envisioned. Now, I think where I diverge from some people that have written about this is I'm a little bit more willing to be skeptical of the original design. I think some people say, well, look, this is not the way the system was supposed to work. And I say, look, we should expect this to happen because the different institutions, legislature, executive, judiciary, they don't really have good incentives to provide the kind of checking on the growth of criminal justice, on abuse of power in criminal justice that we would like them to, that they have incentives to cooperate. And there's an idea here that I can trace back to Bill Stutz. He wrote this famous article called The Pathological Politics of Criminal Law. And he says, in criminal law, legislatures draft broad laws because they're in cooperation with prosecutors. They're basically just drafting broad laws to delegate power to prosecutors. And to the extent we have a separation of powers between these two institutions, it's not really working. I think it's an incentive story.
Mm.
I think we don't have sufficient incentives for the different branches to really be providing the kind of checking we want. And checking is the ultimate goal.
Mm. Mm.
And separation of powers along functional lines is maybe one strategy that's designed to get us that checking. But I think it doesn't do a very good job of getting us the checking that we want.
Right, right. So it seems like a lot of people it's almost like epiphenomenal to what we really want to accomplish in a sense that like, yes, we're seeing this move toward a unitary institution making all of the real decisions, but it's the decision-making part that's important, or rather the sort of the ability to block decisions made by another participant, not the simple fact that the roles are dispersed among different institutions.
Yeah. Like, even if all the different institutions are playing their part, it's not actually going to protect liberty, and do all the other stuff that, we want separation of powers to do. Separation of powers is an instrumental good. It's not sort of an end unto itself. I think not everybody, but most people agree. And so you have to have some theory for why separating out the powers into these different kind of functional branches is actually going to promote those values, is actually going to lead to, fairer criminal justice, fewer abuses of power, and so forth. And what I tend to say is, look, there's no particular reason to think that these different institutions are going to have different interests, and they might all agree. Let's have an unfair criminal justice system or whatever. And we need to more directly attack that problem by figuring out checking mechanisms that are more likely to get us the results that we really care about. So one example of that is our system, because we're so caught up in this idea of the functional separation of powers, this sort of Montesquieu vision of separation of powers between the different functions of government, we actually don't like it when one institution sort of checks another institution's homework. So courts often say, well, people go to court and they say, hey, the prosecutor shouldn't have brought charges, or the prosecutor should have brought these charges and didn't, or, this law is badly written and the legislature should have included this defense but didn't. And courts' usual response to those kind of arguments is to say, sorry, not our job, right? Separation of powers. It's not for us to rewrite legislation. It's not for us to be super prosecutors and review charging decisions. And my answer to that is, who cares whose function it is? Checking might involve multiple institutions performing the same function, duplicating functions. That could provide better checking than just saying, "Oh, that's not my job."
Mm-hmm. Well, so what would a criminal justice system focused on checks and balances rather than separation of powers look like? I mean, can you think of any sort of features that would be most likely to promote that kind of institutional checking, or those kinds of institutional reforms? Or what would we expect to see in a system if we kind of prioritize checks and balances instead of separation of powers?
Yeah, and I offer some kind of thoughts on this in the paper, but what I say is kind of vague. I sort of say these are some ideas, right? And so I'm not going to give you the kind of answers for everything. But but one of those would be, for example, we would probably be being more open to institutions that, check each other's homework, that perform the same job. That's one way. But more generally, we'd want to figure out how to diffuse power over criminal justice among decision makers who actually have some interest in checking each other. And I think we need to recognize that we don't get that just by giving people labels, right? We don't get that by having three different decision makers who are all sort of drawn from the same political class and giving one of them the name judge, and one of them the name legislator, and one of them the name prosecutor. The way we do that is we really actually be more focused on who is making criminal justice decisions, where those people are drawn from in society. And so, one of the things I think, we have to be really attentive to is where do we draw boundaries? Who votes on criminal justice decisions? Are those decisions made at the city level, the neighborhood level, the county level, the state level? Because the answers to that question are going to give us quite different results in terms of the kind of criminal justice that we have. I do think I end up very sympathetic to juries, which I think some people like, because as part of this idea of the separation of powers, I think the juries are great because that they are a check. And what makes them great is they bring in a range of different interests from society into decision-making in criminal justice. They bring in, poor people, rich people, white people, black people, all a range of different voices, and it gives them a veto over the imposition of criminal punishment. Now, as it happens, we have really limited the jury's power. And I think we've limited the jury's power because we're so transfixed by this idea of the functional separation of powers, because we think everybody has to have one job and that's their job. And jury's job is to find facts. Now, I was going to say, if you were going to find the appropriate job for 12 people basically pulled off the street at random, fact finding doesn't seem like it's the thing that you would choose. But what might those people be good at? Well, they might be good at making normative judgments. They might be good at determining when punishment is fair or unfair or excessive or insufficiently harsh, or those kinds of normative judgments. And our system has very, very carefully taken that power away from juries because we think it's not their responsibility. It's the legislature's job to figure out how excessive a punishment is or isn't. And I think that doesn't make any sense. I think we should be much more willing to let juries make those kind of judgments, let them refuse to convict if a punishment is excessive. And we don't do that at all.
Mm-hmm. I mean, it does seem like there's a way in which people kind of conflate juries into judicial branch, and therefore the limits on the authority of the judicial branch seem to be imputed to juries almost in a way.
Yeah, absolutely. I think that they just think that they're in the judiciary. And so only stuff that falls under that judicial aspect are their job, and that includes, basically that seems to be finding facts. And we also don't even let them interpret the law. We used to do that a lot more regularly. But juries haven't been really given that authority in a long time, because that's sort of been wrested away from them by judges.
Mm-hmm. Well, it seems like it's almost like a kind of a tacit realization that juries are doing a lot of that checking anyway, at least in the tiny number of cases that actually make it to juries, right?
Yeah, although we make it really hard for them to do that, right? So one example, and this relates to another paper I have in progress, that I hope to have a draft of, co-writing it with Will Ortman and Wayne State, where that's about the idea of the fact that our system, we shield the jury from any knowledge of penalties. So we say that juries are allowed to nullify by acquitting even in the face of evidence of guilt. That's just sort of a power of the jury. Our system is a little kind of inconsistent of how it feels about that power. For the most part, we think it's bad, but it's kind of just an unavoidable result of juries. But we really don't make it easy for them to do that. And one of the ways we don't make it easy for them to do that is by very carefully shielding them from any knowledge of the implications of their decisions. So let's say there's a crime with a pretty high mandatory minimum. We're not going to tell the jury that, even though it strikes me as quite relevant to the decision they're being asked to make, as on behalf of the community. Does this person deserve to be convicted of this crime, knowing it's going to have this very severe consequence?
Well, so, I mean, what are the implications of this shift you're suggesting? I mean, if our focus should be on checks and balances, do we need to have separation of powers at all in order to maintain a kind of functional, liberty protecting criminal justice system, or not? And are there examples of like institutions where that might work without having separation of powers, but still having checking?
Yeah, I think it depends on what exactly you mean by separation of powers. And I think that's one of the things that makes, writing and sort of talking about this area so difficult, is because of the kind of disagreement about terminology and terminological confusion. I don't think we necessarily need to have the kind of formal Madisonian separation of powers that we see so much, where we have government power that's divided between different institutions at the level of kind of political institutions, a separately elected legislature and executive and an independent judiciary. I do think we need to have some diffusion of power between different decision makers. It doesn't necessarily have to be at the institutional level. I do think that we might want some separation of functions between individual decision makers. It doesn't have to be at the institutional level. And so there are some examples I get into in the paper a little bit about different contexts where we have kind of functioning criminal justice systems, but that don't, strictly respect the traditional separation of powers in all of its ideals that we get from Madison. So I talk a little bit about military criminal justice, and in military criminal justice, you see a lot of the relevant adjudication of offenses by service members they're adjudicated within the confines of the executive branch. And there are various kinds of rules insulating certain kind of decisions from, what's called unlawful command influence and things like that. But it's certainly a much narrower level of, degree of separation of powers than we see, than we're told, by Madison that we should be following elsewhere. And, there are problems sometimes with the military criminal justice system, but it also works some of the time. And there are things that work fine about it. Likewise, I talk a little bit about some comparative law. I talk a little bit about other countries. I talk about England, which is a country that doesn't have, at the sort of level of institutions, doesn't have the same kind of division of power between the executive branch and the legislative branch. Basically, Parliament has plenary control over everything, and they've developed a criminal justice system that's sort of ultimately accountable to a parliamentary officer, and nonetheless, it still mostly functions. So, I mean, I don't think the result is you say, okay, let's just have one kind of like, criminal justice Führer who gets to decide everything. That seems bad. I'm not there. We want some kind of diffusion of power. But I think it opens up, thinking about it this way, maybe opens up more possibilities that might not seem available otherwise. And particularly, it sort of shows that maybe some things that we think are important maybe are not that important. So I talk a little bit about a case from the Supreme Court called Gundy from last term. And this is a case about is it okay for Congress to delegate to the Attorney General the decision of when to make certain kinds of obligations under the Sex Offender Registration and Notification Act retroactive? And the formalists on the Supreme Court, and Justice Gorsuch in particular, think this is a really big deal, and that this is a big threat to liberty because we're violating the traditional separation of powers by letting someone in the executive branch basically determine the scope of a criminal law. And my response to that is just to say, who cares, right? Who cares? Why do we think this is going to protect liberty? The answer to this question is going to protect liberty more or less. Do we have any reason to think the Attorney General is going to make worse decisions or better decisions? I have no idea. If we say that the Congress can't do this, maybe they'll just pass criminal statutes that are even broader and just criminalize more things. Is that better? I don't know.
Yeah, I don't get the impression that Congress likes sex offenders any better than the Attorney General does.
No, and it may be that like the Attorney General will make finer delegations. I mean, we just don't know, and there's just nothing about the formal definitions of the institutions gives you kind of any answer to the question. And so you can think of this paper in some ways as kind of a response to this, increasingly formalist movement of which I see Justice Gorsuch as the most vocal proponent, that sort of insists, the separation of powers is super, super important to protecting liberty. And, it just doesn't, for me, ever get off the ground because they don't ask the why question. And I don't think that there are good answers. Why, when you get into these kind of practical disputes, why do you think that dividing power in this way is going to protect liberty? Is there any reason to think that in practical terms? I don't think that there's a great answer.
Well, one thing I thought was really interesting as well was returning to this idea that, what we call separation of powers ends up in a lot of ways just being separation of parties, was the sort of difference between political actors and kind of like agency actors. And I wonder if you could talk a little bit about the potential role of sort of agency checking in relation to some of these issues. Like, I mean, can like non-political actors play an important role in kind of instantiating some of the kind of checking mechanisms you think might be beneficial?
Yeah, absolutely. So I think that's another sort of interesting dimension or interesting angle that I try to get into the paper is that why we don't necessarily have to assume that all the kinds of checking that we want has to come from different political institutions. And so there's various stories that have been told, about how even within agencies, within sort of single political institutions, like within an administrative agency, there's a fair amount of diffusion of power between, say, political decision makers and civil servants who have some job protections, and they have incentives and interests that might look a little different from those of political decision makers. And John Michaels at UCLA has told a very interesting story, written a very interesting piece about how this is kind of a new version of the separation of powers, sort of post-New Deal version, rather than having the kind of separation of powers happening between Congress and the executive. We're having kind of some checking between the political leadership and agencies and then the career civil servants. And then also the public plays a role. And the public can sort of be aware of what the agencies are doing and kind of voicing their preferences too. And I think that both Michaels and I would agree that what matters is that you have different interests kind of providing some checking. And that's much more important than the labels we attach to them.
So Dan, I mean, I found this way of framing the question of how we should think about maintaining the sort of limits on the scope of criminal justice authority of the government pretty compelling. But there's a lot of people who have been pushing this separation of powers angle for a long time. So I wonder how you think the people who have that kind of perspective, both scholars who sort of look at this problem through a separation of powers lens, and maybe even formalists like Justice Gorsuch et al., who have a sort of their own version of that lens. Like, how do you think they're likely to respond to the kind of arguments you make in this paper?
So I think that's a really interesting question. I think that one response I may get, from people who have been pushing sort of separation of powers angle is just to say, well, you're right that checking is most important, but our Constitution provides that checking through separation of powers into functionally differentiated branches, and so we should at least enforce that. Because the kinds of solutions you have on the table are not really available. My answer to that is to say, well, I don't see any reason why we should care about enforcing the functionally differentiated branches. And so I don't see that, I'm not persuaded that that's an argument for being formalist about separation of powers. And there's other things that we could do even within the confines of our constitutional system that would be more consistent with what I'm arguing for, like changing how we think about the jury, giving the jury more power, and other things like that. Now, what would someone like Justice Gorsuch say? I've wondered that myself, and I certainly have not had the opportunity to ask him. I don't expect to anytime soon, but because I read his opinions and I'm very puzzled by them, because he really seems to he writes as if he's really kind of drunk the Kool-Aid on just this idea that our separation of powers, the Madisonian design, is like really, really important. And it's like the key. It is the key to protecting liberty. And I just think that that's wrong. I don't think that makes any sense. I think it has no basis in sort of realistic theory about the way the world functions. And so I just don't get it. And the thing that I don't really know is it just rhetoric that has some other justification for it, or does he and maybe like Justice Scalia before him, who did the same kind of thing, who sort of extolled the virtues of this design, does he really, really believe it? And would he care if I were to say, look, this may be what the founders' design was, but it's just wrong. It just doesn't make any sense. Would he care? Or maybe he would just say, look, but nonetheless, it's the Constitution they wrote, and we're stuck with it, so we got to enforce it. I'm not sure.
Yeah, no, I kind of wonder myself, and I guess we'll see as we learn more about Justice Gorsuch's perspective in the coming years.
That we will, for better or for worse.
Well, thanks so much, Dan.
All right, thanks for having me, Ryan.
Yeah, I love it, and just FYI, law review editors, this piece will be available pretty soon, so you should definitely snap it up.
Please do.
So we know when to start. 1, 2, 3, 4. You can't deny that cut flowers given time will surely die. They'll do fine with candles and some wine, but it's a crime. Yeah, it's a crime that you're kissing on that girl for all to see. And it's a crime that she's going home with you and not with me. It's plain to see that boxes of candy will make you sigh. But confidentially. They'll just rot her pretty teeth, and it's a crime. Yeah, it's a crime that you're kissing on that girl for all to see. Yeah, it's a crime that she's going home with you and not with me. It has been proved that pups and kittens too will make you swoon. But it stands to reason that they'll just give her fleas, and it's a crime. Yeah, it's a crime that you're kissing on that girl for all to see. Yeah, it's a crime that she's going home with you and not with me.